welcome folks in. We're gonna have a start on time today because we have an hour and it's our last in the 5-part webinar series between the SRC, the Shridath Ramphal Center, and the tralac, trapca, Afronomics Law in this inaugural sort of Caribbean Africa trade series. So welcome everyone. There's some of you who have survived the entire 5-week course, and we're really, really happy to see you. Those who are new to the webinar series, it really sort of emanated from a discussion that Kolo and I were having about trying to educate both sides of the Atlantic about each other's regional integration schemes and think about really, discrete topics where we could invite experts to talk about their areas and through the process sort of learn from each other, but also sort of draw lessons that we could and best practices that we could actually utilize in ongoing academic work as well as practical work, so negotiations, and who knows, this could emanate or culminate in some kind of formalized agreement between Africa and the Caribbean. So welcome. Today we're going to be talking about our favorite topic, at least as co-facilitators, Kolo and I, dispute settlement, the dispute settlement mechanisms that have been developed under the regional economic communities in the Caribbean, so under CARICOM, as well as under the various regional economic communities in Africa, and culminating now in the AFCFTA, which has a dedicated chapter on dispute settlement. So through, the next hour, we'll be learning about the different characters of dispute settlement. What are the features of the institutional setup for the African and the Caribbean courts or other dispute settlement mechanisms? And I think this is really important against a backdrop where in the WTO anyway, at the multilateral level, these are two of the regions, the Caribbean and Africa, that have sort of seen the lowest incidence of dispute settlement. In the case of the Caribbean, we've only had one case in which a Caribbean country brought a case against another member. Well, two actually. Recently, we also had plain packaging, but Antigua and Barbuda, and then the Dominican Republic and Cuba recently brought some cases before the WTO dispute settlement. There have been cases where the Caribbean countries have acted as third parties, and one or two in Trinidad and Tobago where they were sort of respondents in the context of disputes. And Africa, you'll see a similar, I think, profile where you have South Africa may be the most sort of active in dispute settlement, but for a continent of over 50 countries, it shows, I think, a discomfort, a lack of trust, a lack of experience in dispute settlement. So it's interesting to see how any of that plays out in the context of these regional courts that they have set up for themselves in the context of these economic communities. So we're really, really excited to hear from our experts. And before I move to introducing these experts, I'm going to let my co-facilitator say a few words, and then we can get started. Kolo?
Thank you very much, Jenny. I mean, I'm not really going to say much, but just to say thank you so much for joining us again in this last webinar. It's just incredible that we've already had 5, and we really thank you for your support. And I mean, also just to kind of highlight also the low, on dispute settlement for both regions. And it's very interesting as to the reasons why, and maybe we can touch upon that in this webinar as well. But it's also going to be interesting to see how these two regional, dispute settlement mechanisms actually adapt to the realities of what traders need on the ground. And I think that's something that going forward is something that should be explored. But without any further ado, I am going to go ahead and introduce our first speaker, who is Professor Olabisi Akinkugbe, who is an assistant professor at the Viscount Bennett Professor of Law, at the Shridath Law School at Dalhousie University in Canada. He's got a PhD from the University of Ottawa, an LLM from the University of Toronto, and an LLB from the University of Lagos in Nigeria. He's also a co-founding editor of Afronomics Law blog, which focuses on all aspects of international law as they relate to Africa and the Global South. And this is a very young, but very vibrant community. So if you haven't yet checked it out, I'm going to put a plug in for them. Please do. He's also a founding editor of the African Journal of International Economic Law. He sits on the board of various journals and societies in this field. His research interests are at the intersection of international economic law, international human rights law, international investment law, and law and development. And he also explores these issues from a national, regional, and international context. So a warm welcome to you, BC, and we're looking forward to your interventions.
Thank you, Kholo. Let me now, with great pleasure, introduce a compatriot, Mr. Claude Chase, who's an international lawyer based in Geneva with a specialization in WTO law and dispute settlement. Claude has quite the experience in dispute settlement, having worked at the WTO Secretariat as a dispute settlement lawyer at the Appellate Body Secretariat, and in the private sector, international trade manager at the headquarters of a multinational company and as associate of 2 international law firms. Claude has in the past conducted research on dispute settlement mechanisms in regional trade agreements and was the lead author of a 2013 working paper at the WTO that extensively mapped and analyzed the dispute settlement mechanisms of regional trade agreements that have been notified to the WTO up to the end of 2012. He's a Caribbean national, a strong proponent of Caribbean integration, and actively follows the work of CARICOM's Regional Trade Court, the Caribbean Court of Justice. I'll also give in another plug for Claude because he joined me as one of the experts who worked recently in compiling a digest of all the Caribbean Court of Justice's case law in the jurisdiction that the court serves as the court of trade for the trade resolution and interpretation of the rules of the revised Treaty of Chaguaramas, which basically sets up CARICOM. So very well placed to speak with us this morning. So without further ado, we actually have shaked up the programming a little bit this time. Instead of giving, sort of free rein to the speakers to just talk generally about the courts of which they are experts, we are instead going to choose a different format and just basically ask questions that they will each answer in turn based on their experience of their region and their regional court. So we thought we would, for the last webinar, shake it up a little bit for you. Please feel free to place your questions as we move along. We will try to integrate them into the questions, into the Q&A or the chat function. So to get started, I'm going to hand over again to my co-facilitator, Kholo.
Thank you very much. So as Jenny just explained, we will be posing questions. So the first question, and obviously the question would, apply to both Claude and to BC. And BC will answer the question first. And so the first question is, can you please briefly describe the main features of the dispute settlement system, or at least the courts that have been set up to administer, interpret, and apply the rules in Africa and for Claude, the Caribbean regional economic communities? And, I think also would be really interesting to hear what would be the unique features and maybe some of the copycat features that, present in the systems. And also maybe you can throw in about the independence of the courts or the dispute settlement mechanism systems that have been set up. Over to you, BC.
Okay, so much to you, Kholo, and to Jean for putting this together, and to Samuel, who has been doing a lot of the IT work. Equal thanks to Claude and to all who have joined us today. So the first set of remarks, that I'll make in response to that question really is about the fact that once we're thinking about international courts in Africa, the regime is very diversified. In other words, we can think about this, imagining them on 2 broad scales. One would be what is the regional level that covers the entire continent and the other will be the sub-regional level that caters to various regional economic communities, as Jean mentioned, across the continent. Now, so the point is that international judicialization then in the African continent hasn't always been there. If you're thinking about 1970s, 1980s, there were no regional courts or international courts that were active on the continent of Africa. These courts emerged in the 90s, early 2000s, and have since really charted a path for themselves. At the regional level, we can certainly think of two courts now. Well, maybe one court and another tribunal, more so. We can think first about the African Courts on Human and People's Rights, which started functioning in 2006 and has had over 250 cases initiated before it, even though it hasn't really gone full length with more than a dozen or so. And always talk about how that came to be, how people approach those courts. But on the other hand, you also have, as Jean mentioned, something which is one of the protocols that was appended to the agreement establishing the African Continental Free Trade Area, which is the Dispute Settlement Protocol, the rules and procedures relating to settlement of disputes under the African Continental Free Trade Area Agreement. That particular one has a dispute settlement mechanism that is modeled after the World Trade Organization dispute settlement system. And so you would have the consultation by parties, panels, and then the appellate body that follows. But maybe more interesting are the regional, sub-regional economic courts that I've mentioned. And in this situation, we have many of them. And I think it's probably important not to sort of gloss over these courts. So permit me to just mention some of them, if not all. I have them in front of me. You have the Arab Maghreb Union Judicial Authority. You have the of the market of Eastern and Southern Africa, which is usually called the COMESA. You have the East African Court of Justice, which is the EAC. You have the Court of Justice of the Economic and Monetary Community of Central Africa, CIMAC. You have the Economic Community of West African States Court of Justice. You have the Community Court of Justice and Arbitration of the Organization of the Harmonization of African Business Law, popularly called OHADA. The Southern African Development Community Tribunal with its own unique challenges. The Court of Justice and Economic Monetary Union, and then the Arab Court of Justice of Human Rights, which was adopted in 2014 and has yet to take off. The key in mentioning all of this is to say that Africa has a lot of these sub-regional courts that are established pursuant to sub-regional trade agreements that exist on the continent. We can always get to the question of how these courts are unique in their sense, but one general point I'd like to note is that the operation of the sub-regional courts have shown demonstrated significant levels of boldness from the judges in how they have made their decision. The courts have decisions on trades, and that's because the member states have not always brought trade disputes before them. But like I said, not always. So it means some of them actually do settle disputes these days that border on trade. And all these just mirror the fact that these courts in their establishment are young at heart, being of incidences of late 90s and early 2000s, but they have, in that short time, also been able to map important trajectories. So two of those courts, which I'll commend to anyone, will always be the East African Court of Justice and their court to invest always. For now, I'll stop there. So I just said for now, I'll stop there. If my internet goes a little bit.
Yeah. No, I mean, thank you. I mean, I was just going to comment on the fact that you broke up a little bit at the end. So hopefully we can resolve those issues. So Claude, I mean, you've heard the African system is multi-layered. There's multiple courts and dispute settlement systems, and just how do they compare, and what would be the unique features in the Caribbean?
Thanks very much, Kolo, and thank you to you and Jenny for the invitation. Yeah, I mean, I think my task is a little bit easier than BC's because the landscape is a lot simpler in the Caribbean. So within the Caribbean, the main regional economic integration scheme is called CARICOM, initially established in 1973. That process of integration was deepened with the 2001 revised Treaty of Chaguaramas, which sought to further expand the process of integration and to establish the Caribbean single market and economy, moving from free movement of goods to free movement of services, capital, and people. When the RTC was established, and I'm using the RTC as shorthand for the revised Treaty of Chaguaramas, it also established a Caribbean Court of Justice, which took which introduced the rule of law into the trading regime. So it transformed it to a voluntary sort of based regime to a rules-based regime. So it's established by the RTC in 2001, as well as by the agreement establishing the Caribbean Court of Justice, and it was inaugurated in 2005. Now, in terms of its features, it is an extremely unique court, especially when you compare it to other dispute settlement mechanisms of regional trade agreements. So maybe I can go through some of these features. So let's start with the fact that it's a standing permanent tribunal, which obviously is quite unique because the vast majority of regional trade agreement dispute settlement mechanisms establish an ad hoc panel system that largely mirrors the WTO panel system. So it's a standing permanent body. It's composed of 7 judges at the moment, including the president. And so in that regard, it stands out from other dispute settlement mechanisms of RTAs, perhaps with the exception of the European Court of Justice, the Andean Community, and certain tribunals of particular African regimes. Another feature is that it is a dual jurisdiction court, which is entirely unique. So the court operates as a domestic court and an international court in one. So on the one hand, it serves as an appellate court in civil and criminal matters for those CARICOM member states that accept that jurisdiction, while on the other hand, it has an original jurisdiction in which it has compulsory and exclusive jurisdiction to interpret and apply the revised Treaty of Chaguaramas and secondary community law. What's interesting here is that it's not that you have 2 separate jurisdictions with 2 separate sets of judges. So the same judges who are looking at municipal law are also interpreting and applying the revised Treaty of Chaguaramas. And we can talk about this later, but why that's interesting is that you can see that that has led to somewhat of a Caribbeanization of international law, where you can see domestic legal traditions and systems influencing the way in which international law is interpreted and applied by the CCJ. The third feature of the court, which I think might be important to point out, is that it is not exclusively a state-to-state system, which is typically the case in international law generally, and especially in international trade law. So it allows private parties to directly bring claims against member states as well as CARICOM bodies and institutions with the special leave of the court. So if they've satisfied certain criteria, they can directly bring a claim against member states. And that has generated all of the court's activity, and perhaps explains why there is quite a lot of activity, or a fair amount of activity under the CCJ's original jurisdiction compared to other dispute settlement mechanisms in trade agreements where there is practically none. It also has an advisory jurisdiction. That's also an interesting feature that's quite unique. And then, Kolo, you were mentioning at first features with respect to independence. And I want to highlight those because I think that really sets the CCJ apart, not just comparing it to other international trade tribunals, but comparing it to courts generally and to courts of international law. So when we think about features that induce independence, first I would like to point out the funding of the court. So the court is actually not financed by member states, which is entirely unique. How the court is financed is that when it was inaugurated, there was a trust fund created with an initial capitalization of $100 million US, representing a grant from all member states. that initial capitalization was invested, and the court is funded off the proceeds of that investment. So the court is never beholden to make certain decisions out of fear of being deprived of financial resources. Also, with respect to the appointment of judges, judges are not directly appointed by member states with the exception of the president. So the president is appointed by member states. On the other hand, all of the other judges are appointed by an independent body known as the Regional Judicial and Legal Services Commission, which is composed of a broad section of society, including civil society, the private sector, the academic community, etc. So there's quite a bit of separation between member states on the one hand and the appointment of judges. Beyond the appointment of judges, even with respect to their tenure, they do not serve renewable terms. So they serve until they reach the age of 72, which can be extended to the age of 75, but the extension occurs not with the concurrence of member states, but on the basis of decision by the Regional Judicial and Legal Services Commission. So there's actually a lot more I could say, but I think for now I'll stop here. I think I've highlighted a few features and we could probably get more into it later.
Oh, that's an excellent start. And, you know, if at any point, you know, BC or Claude wants to sort of react to each other, the whole point of this more interactive format is to facilitate, you know, cross discussion about what you were saying. My question is sort of, so it's a natural segue from the first one, which is, yes, there are these courts that have been developed, etc. Yes, everybody would really want to know, how have the courts been utilized? What are their compliance rates? What are their utilization rates? What can we say about how effective the judgments have been? And effectiveness itself is a question of open academic debate. How do you measure effectiveness? Is it the number of cases? Is it the quality of the cases? So I guess my sort of my bumper question is, how have the courts fared since they have been established, and how effective have they been by reference to whatever metric you deem appropriate? So we'll go with BC first. And again, if you wanted to react to anything Claude said before, it's a free-for-all.
Oh, for sure. Thanks. Thanks, Jan. And I think first is to say, okay, so I broke up towards the end. Again, just let me know. I'm happy to restate the point. But the two courts I mentioned that I think have been at the forefront of trade disputes settlements are the East African Court of Justice, OHADA as well. And then to some extent, the ECOWAS Court of Justice has also been doing its own part. I think something that is interesting before going into the second question from Jean, from Claude's intervention is that, you know, whereas you can provide that sort of homogeneous analysis, right, about the CARICOM, CCJ, you can do so about the regional courts and the sub-regional courts in Africa, right? Like I said, you have about a dozen at the sub-regional level, and then you have the African Court on Human and People's Rights, as well as now the AFCFTA dispute settlement mechanism. But one point to note is that in relation to at least, for example, the ECOWAS Court of Justice, were a major challenge when this court was established in 2001 or thereabout. In fact, that court went on for about 5 to 6 years or 7 years without actually having a real case on its docket. And a lot has been written about this and how they had to re-engineer and, you know, redesign how and who can come before this court to be able to expand their jurisdiction, to make it not just about trade, and then make it primarily human rights and give individuals and NGOs access in relation to the human rights disputes, and then retain the trade disputes for the state settlements. And I think that provides a very good inroad into the second question Jean mentioned. So I'll stick with for my analysis with the ECOWAS Court of Justice and not be everywhere on the map. And so for the ECOWAS Court of Justice, it's interesting because you can't think about issues of utilization, compliance, or effectiveness without imagining who are those that can come to the court, right? So even though the ECOWAS Court of Justice was established initially with the thinking that member states will bring trade disputes before this court arising out of ECOWAS revised treaty. That was not the case because, as I've just said, for many years, member states just did not bring disputes to the courts. That, in fact, is a very unique aspect of the settlement of disputes amongst African states. They hardly drag themselves to these courts, and that, to some extent, reflects why there's paucity of member states being driven before the WTO dispute settlement mechanism. And so when, for about 7 years, nothing happened before the ECOWAS Community Court of Justice, of course, the redundant, there was a case that was brought popularly known as the Afronomics case then, which involved this guy and Nigeria and an individual, right? And it became apparent that the court could not pronounce on this one, even though it had impacts on the capacity of this individual to trade cross-border. And so what happened as a result of that was that there was a move engineered by the judges in concert with NGOs, going to the member states to really let them know that they need to expand the jurisdiction of the courts in two ways, both in terms of actors and in terms of substantive matters that can be brought before the courts. And so, whereas previously it was only member states that could come before the courts, now it was expanded to include individuals and non-governmental organizations. And substantively, in respect of these two new categories of persons, they can bring disputes bordering on the settlement of on violation of human rights of theirs in any of those situations. And so with that, you've seen a floodgate of cases, right, being brought before the ECOWAS community. Just from criminal matters to environmental matters to education. And so they really covered the broad spectrum of not just civil and political rights, but socioeconomic and cultural rights as well. And before those courts, you've seen citizens, NGOs and individuals who have brought these cases invoke not just constitutions, not just regional instruments, but there's also invoked UN declarations and instruments at that level as well. And so utilization is very good. There's a very active, very healthy engagement with these courts. And you can say the same about the ESCJ, unlike the SADC tribunal, which at the Campbell case that was brought before it meant, there was significant backlash, as it is called. That meant that court was not so, the tribunal was not existent for a long time as a result of non-appointment of judges to its board. Now, compliance and effectiveness, and then I'll pass on the baton, is one that is huge. The first question I like to say is it matters how we think about compliance or effectiveness, whichever way we want to look at it. I said in my initial remarks that these courts were established in the late 1990s and early 2000s. So it means once we're thinking about the notion of impact and effectiveness, we have to not be too quick to subconsciously or consciously look at these mechanisms or these measurements with an unconscious rendering of the European system that we've come to know, which has existed for far longer time. I have written in my own work, here and others have also written about this. For the African courts, we have to think about impact and effectiveness on compliance in a different way. While compliance metrics by which these decisions that are given by these courts may not map onto our understanding of how national courts operate, they have nonetheless continued to be effective. So let me give an example. It is not impossible to imagine that in some of the cases, they've gone to court strictly to try to get those cases active, to be able to embarrass or name and shame, right, their national governments. And in doing so, there's a strategy, there's a motivation that inspires the litigators to be able to keep those courts there. Oftentimes, these litigants are shut out of the national court regime. And so when they land before the regional courts, their motivation is not just to get a substantial that ruled in terms of black letter law in their favor. Rather, they're using it as a strategy to try to engineer and put pressure and keep in the public sphere debates that put their national governments in shame. So it's the point I'm trying to make in terms of this long-winded answer is that whether a court is effective or not is a question that's open to debate. And for the regional courts in Africa, sub-regional courts in Africa, we have argued that they have been effective. They are effective when we think about effectiveness, not in the traditional way we've thought about them of just implementing decisions or enforcing decisions of courts, but in terms of all the wider strategies that inform strategic litigation before this court. I'll be happy to say more about that, but I'll pass on to Claude for now.
Claude, over to you now. I see there's a really interesting question from Justice Anthony Gafour that we'll get to, I suspect, with the next question. But Claude, please go ahead with the question, and you feel free to respond.
Sure. So, I mean, in terms of how the CCJ has fared and whether it's been effective, I mean, I agree with BC and also with what Jan said when she prefaced her question. You know, it's really a source of academic debate, you know, what and whose metrics you use to determine effectiveness. But I would say, okay, if we take a number of factors, which include utilization, the access to justice, so ensuring access to justice and a means to vindicate rights under the treaty, compliance, and fostering security and predictability. And the last factor I think is really important in any trading regime. I think the CCJ has fared very well. If we think about utilization, so the court was inaugurated in 2005. I think it took a couple of years for the first trade case to be brought. And I know Yves will correct me, but it's either 2008. Yes, so 2008 was the first trade case. Between then and 2021, we have 35 judgments rendered by the court. But that being said, 35 judgments doesn't mean 35 cases, because in many of these judgments pertain to a single case, because the court has rendered an initial judgment on special leave, an interlocutory judgment, a final judgment, and a supplementary judgment on costs, for example. So I would say, though, when you consider the size of the Caribbean, the volume of intra-regional trade, the presence of major manufacturers in the region, etc., I think the utilization rate is quite good. It's fair. However, one thing that I would point out is that all of the case law has been generated by private individuals or companies. And it must also be remembered that the court was envisaged to be state to state, with private complaints being exceptional. But as it turns out, private litigants have really been the driver of the court's work. Which takes me to another point, which I think shows the court's effectiveness, because it has been quite expansive in how it has interpreted the provisions which permit private entities to bring claims. It has also ensured access to justice for basically all, you know, economic operators within the region. So I think if you look at the case law, you will see cases that deal with free movement of goods, and most of that case law involves the cement industry, and that's because you have a large regional manufacturer and you have intense competition from extra-regional imports of cement. And then on the other hand, you have a separate category of cases which deal with free movement of persons. And when you look especially at the cases on free movement of persons, you can see how, as a result of the court's existence, you have people really, you know, of ordinary means who've been able to access this international court and to have their right to free movement within the region being vindicated. In terms of compliance has been quite good. In fact, I think I'm aware of there being cases of temporary non-compliance, which have subsequently been rectified, but certainly I'm not aware of cases of persistent non-compliance. And under the treaty itself, the RTC places an obligation on member states to enact in their domestic laws legislation that would make it possible to enforce a CCJ judgment as if it were a judgment of one of their domestic courts. So I think compliance has been good. The legal framework is there to ensure compliance. But in addition to that, in a small community of member states, I think reputational cost in terms of non-compliance is quite high. And so far, you know, the compliance rate, I would say, has been, well, not just fair, I think it's been very good. But all in all, I think the court has been effective. I think it's fared well. And I think through its case law, and I could point to it, as I said, its case law on the free movement of persons, and also its case law on the administration and maintenance of the common external tariff, which is really important in determining how, you know, the local manufacturing sector fares vis-a-vis extra-regional competition. It has really, you know, set out and clarified the rules of the road for trade in the region, both in terms of free movement of goods and free movement of services.
Thanks a lot, Claude. I mean, for me, it's very interesting, the sort of the differences in the courts. I mean, we've heard from both speakers that they've both been effective in their own way. But what's interesting is that it seems like the CARICOM Court of Justice is quite, you know, especially in that it's actually dealing with trade or direct trade related issues for which the treaty was developed. But in the African context, you know, after years a dearth of, you know, utilization by member states, giving, you know, private actors and people to access to courts has actually expanded the mandate of the courts to more human rights issues and criminal law issues that maybe were not, you know, sort of thought about initially in the initial treaties. So I think that's a very interesting sort of point. And BC, before we go on to the next question, I would like to ask a question that was posed by Taimun Stewart in the chat, and he says, thanks for the clear explanation of the African take on effectiveness. Can you link the uniqueness of the evolving courts in Africa to any retention of indigenous cultural modes of dispute settlement, as opposed to, for example, the Western modes, if this applies at all?
Okay, so thanks a lot, Kolo, and to Taimun. Nice to hear from you or to read from you. So I guess I was going to say one thing before responding to that we have to ask what these metrics that we've come to understand do for assessment of this court, right? When we think about the usefulness of courts, only in terms of compliance, what are we doing, right, by thinking in that way, right? Frameworks are not only frameworks that we should understand. Are those frameworks sacrosanct, in fact? Can we rethink them based on cultural, political, and unique social contexts of different regions? And I think that ties very well to Taimun's point. But on the compliance issue, what I wanted to say is that, look, there is a broad narrative out there, which we all in our scholarships try to kick against, that these courts are not just failed regimes. These courts actually do important work. And that's why they've continued to exist. Now, those work that they do may not map onto your understand historical of what and how courts operate, but it doesn't make them any less important for the purpose of analyzing them. And so some of the materials I've put in the chat box really speak to that in broader context. And so to Taimun's question specifically though, the uniqueness of African courts to any retention of indigenous cultural modes, I think we have to be careful here, right? Indigenous cultural modes also differ generally. So I can't say if there's a specific one we have in mind in here. But the reality, African states have preferred in the adversarial manner in which we have worked them out, right? You've seen, and I think I can have the post here shared. If you look at this writing here on the evaluation of the dispute settlement system, which I'll share with everyone, this talks about how the African Continental Free Trade Area Dispute Settlement Regime can really learn from sub-regional courts, the COMESA court, and other ways by which member states have been able to settle disputes, right, through reviews, mechanisms, and other ways, instead of going to the court. And so I don't think you can write existing right now, indigenous modes of settlement disputes into potential court regimes that are expected to settle transnational disputes if you really take them the full length. But can we at least imagine the socio-cultural context within which these parties operate as the basis for thinking about them? So my own argument has been that opportunities exist in the consultation mode, right? You do see that that is existent in the dispute settlement regime of the African Continental Free Trade Area. And that place we have parties without engaging in these expensive modems of the Western regimes, right? And I'm not the only person who has spoken about it. Tanganyika Malua has written about this as far back as 1980s in an article I can post on there, talking about the peaceful means of settlement of disputes amongst African states. And so I think that to be pointed on that question, a Western model of dispute settlement is important. It helps, but what we kick against is the critical context, because that does not just work once you think about the lay of the land of that particular part of the continent. Okay.
Thanks for that, BC. I actually want to rope back and throw it back to Claude. This whole question about that Justice Anthony Gafour has asked, which is, although you went into it in some detail in talking about the evolution of the case law in goods and services, I think the more general question, if you can take a stab at, is how important has been especially in light of what BC has just said, which is that we generally, use these sort of lens to think about effectiveness in terms of, how often a case is brought, etc. And I'm just looking at something that he posted by James Gathi, which is business people, especially in our regions, perhaps prefer a non-judicialized way of settling disputes. And this is not obviously to encourage extrajudicial ways of settling disputes that are underhand and really about graft and these ways. We're talking about legitimate ways of settling disputes that are not necessarily ones that see the light of day in terms of the court system. And I think Tanya, Goddard is asking a question about the move towards mediation and conciliation of trade disputes and how can that be utilized. But the broader question is, how important has this process of Caribbeanization of international law in terms of the CCJ's impact within the Caribbean region, as well as international law in general, been, I guess, facilitated by this court, and just roping in all of these other elements of, maybe, yes, the court has been successful, but for our way of sort of being and the Caribbean way of thinking about the issues bedeviling CARICOM, is there a take you have on how Caribbeanized the system has become? And on the other hand, is there another way of doing it? Because as you know, in Chapter 9 of the RTC, there are other ways of settling disputes through conciliation, mediation, consultation, etc. As a nuclear question, but you can take whichever part of it you like.
I will try my best, Jan. Look, I mean, as it relates to, we focused a lot on utilization and using that as a metric for effectiveness. I'm very doubtful about that as well. And that's because, look, litigation and having litigation, increasing litigation, as far as I'm concerned, that's not a goal. Having, X number of cases, 50, 60, 70 cases, that's not a goal in itself. What is a goal, however, is that if a private entity, a member state, has identified a trade irritant, there is a trade tension, and they have tried diplomatically to resolve a dispute and they have not succeeded, that the rule of law can kick in and that there is a way in which they can approach a court, an objective third party that can apply rules of international law, that can interpret and apply the treaties and secondary community law that members have generated and can resolve the dispute in that way. I think that is important. And I think that's where the CCJ plays an extremely critical role. And I do think that I remember in the first couple of cases, that the CCJ, so first couple of judgments that they issued. And I was reading these judgments, and of course, coming from, more the WTO system, I was reading these judgments with a WTO lens. These are how international courts typically do things. And so this is the right way. I'll tell you though that over time, I've come to appreciate the way in which the court approaches adjudication. And I call it a Caribbeanization of international law. It's got a special flavor, the way in which the court approaches treaty interpretation. It's very different than how international courts, or say the WTO panel or the appellate body, engages in interpretation. It's a more teleological approach where they're quite aware of the objective of Caribbean integration. They're quite aware of advancing the integration movement, and even the way in which cases proceed, which is what I was saying in my initial remarks. You can see how domestic legal systems and traditions have permeated just the procedural aspects of cases in the original jurisdiction. And so I think it is a very good example of how a regional court can almost, put its own stamp on Western notions of international law and dispute settlement. And finally, Jan, quickly, just about the availability of alternative means of dispute settlement. Obviously, as you pointed out, Jan, in Chapter 9 of the RTC, those means are provided for. Now, I think the problem is that we don't have an accurate record of to what extent these means are being used, at least to my knowledge. I'm not sure that this is published. But I think, look, at the end of the day, what's important is that potential users of the system and economic operators within the system are aware of the menu of tools that they have at their disposal. Some cases may lend themselves to be resolved through alternative, means of dispute resolution, through mediation, etc. There's some cases where that would not suffice, and you'd need to go, through a formal litigation process. So I think within the CARICOM system, we have that sort of full suite of tools, and I think each one plays its part. But certainly, I think the CCJ, through its original jurisdiction, stands as the centerpiece of dispute settlement in the region, and sort of really in transforming CARICOM from the voluntary system of rules that it was to a rules-based system that's functioning in accordance with international law.
Thank you. Thank you very much to you, Claude and BC, for your interventions. And I think what's very interesting is this concept of Africanization or Caribbeanization of dispute settlement processes. And maybe we can sort of deal with this as you answer the next question. But my question to both of you is how do the courts deal with, domestic law? As you say, in the Caribbean context, there's been interpretation of domestic law. Is the judicial notice taken of the domestic judgments, etc. And also in, as you said, BC, it seems like in the African context, to the extent that, private parties use the courts, where they're closed off to access in domestic courts, it seems like there's a supranational court that interprets domestic law in the region as well. So I just want to talk, to the extent that you are aware of this tension between, supranational courts, making pronouncements or even giving, in the African context, judgments on, a national regulation that it would not have, was not available to, or recourse was not available in the domestic legal system. But I think this is also forms part of the bigger question that I'm going to ask you, is how have the courts advanced or set back or not affected the rule of law sort of in the region or in the regional integration process, and also, or the regional projects in the communities of which they form part? Has the jurisprudence been impactful? And if so, maybe you can explain some of the ways that the jurisprudence has impacted the rule of law in general, in the idea of integration in the Caribbean and in Africa as well. BC, please, if you can start.
Yeah. So thank you very much. And so those are great questions. And I think in the time we have, I'll just try to be as succinct as I can in responding to them. In relation to the issue of domestic law, you see, the courts have been very strategic. the judges now, I'm referring to, in how navigate these issues, right? In the sense that on the one hand, they are aware and conscious of the fact that they are not quite your supranational courts in the strict sense, right? Although the amendment, for example, in the ECOWAS context, anticipated that they will function in that way, in which case their decisions will have binding effect and should be implemented directly and enforced. It hasn't always been so. In fact, it looks like if you want to go by the compliance metric, that they've been disobeyed more than they have been obeyed, right? And so that's one bit of it. But how are they navigate issues? They are careful on what they make decisions on. They are careful on how they actually advise their member states to take steps to amend or correct situations where they think they can't give orders on. And so the way in which the courts on the sub-regional level couch their reliefs, couch their judgments, become very interesting when you read them, right? And so they make suggestions that rather than say, we mandate state A to take steps B, C, and to do A, B, C, and D, they will say we require them to take steps, right? Means the state can forever, they're taking those steps to do so. But specifically, they are careful not to dabble on issues of constitutional matters. They recognize their limits. And so they won't just bother on it. Although there are regimes that require state parties, parties before this court to exhaust or not exhaust local remedies at the national level. ECOWAS does not require that in relation to violation of human rights. When it borders on a specific matter on which the member states have exclusive rights to legislate on, they wash off their hands. And so what you then find is that in those areas where they have been bold, as I said previously, imaginative, the hook on which these courts hand the cases becomes the human rights lens. And so they'll say, well, to the extent that this involves potential or actual violation of human rights, we can sit on it. But if the issue brought before us does not have anything on which you can do that, then we're out. And that's the strategic litigation aspect, one strand of it that I referred to earlier. Impact of this court, as you've said, the courts have been impactful. Their impact hasn't been that BC has approached the courts, his alleged violation of his right, a judgment that confirms that, and that Nigeria complies with that. That's not the case. It's been in the ways in which BC uses it. And so I've just put in the chat box, which is something I wrote on the megapolitics jurisprudence of the ECOWAS Community Court of Justice. And these are cases that more or less ensued from disputes arising out of constitutional amendments or unconstitutional amendments, as well as election cases, which has strong resonance in constitutional law at the national level. See how the courts maneuver, citing various legislations outside of the national sphere in relation to the regional and international, to be able to adjudicate on what are essential political and civil rights, and at times socioeconomic rights that may have been breached. And so the word of caution to sort of pull it together is that understanding these regimes on their own terms matter. This is not a case for non-recognition of rules-based regimes. No, but rules-based regimes that are underpinned by the unique socio-political context and cultural narrative. And doing this means we should not only locate the usefulness of the cases before this courts by looking at the decision of the courts. We should look at the national context from which they emerged as well. Thanks.
Really, really important thoughts there, BC. I know we have 5 minutes left, so I'm actually going to throw the same question that Kholo asked to Claude if he has any reactions, and then we'll close.
Okay, maybe just quickly, I mean, and I think I've covered some of this in my earlier responses. I think the short answer is, the CCJ has absolutely advanced the rule of law in the Caribbean Regional Integration Project. Or actually, how I would phrase it is, they have emphasized the rule of law in the operation of the CARICOM single market and economy. And if you read the court's judgment from its earliest judgments until now, that is a factor that the court is almost at pains to say in every single one of its judgments. And you can tell that it permeates its approach to treaty interpretation and application in concrete cases. This idea that this is no longer a voluntary regime, that rules are rules, and that if member states have certain obligations, that they have to abide by them. And you know, in that regard, stressing on the rule of law, perhaps one interesting case is, and this is a unique feature, I think, of the court. As I pointed out earlier when I was talking about the court's features, the court awards compensation to litigants that can demonstrate a violation of the treaty. And that is not a treaty mandate. The court, in one of its earlier judgments, says that because we are now a system of a rule of law, that implies that member states have an obligation to compensate where they have violated the treaty. I think that in turn has advanced sort of the goals of integration in the sense that it gives confidence, say, to private sector entities, that when they are aggrieved by an offending trade measure of a member state, they can approach the court and not only be granted, let's say, a Pyrrhic victory, but they can be made whole again in the sense that they can recover what they have lost as a result of an offending trade measure. And maybe I think the largest impact it has had, the court, in advancing the goal of integration is with respect to the case law in two areas. First, how they have approached the question of granting special leave to private individuals to approach the court. The court has been very lenient in its interpretation of the criteria that is set out in the treaty. And it has interpreted those criteria in a way that makes it not very difficult to overcome for private individuals. The second area is with respect to the free movement of persons. I think that advances in the most serious way the goals of integration, because the court has made it very clear that the right to move between CARICOM member states and to enter CARICOM member states for CARICOM nationals is a fundamental right subject to very narrow and limited exceptions. And because you know, the free movement of people is one of the fundamental pillars of the CSME, I think in that way, that line of case law which looks at the free movement of persons is a line of case law that definitely advances the regional integration project.
Excellent, guys. I mean, there's so much there. I mean, an hour does not do any of it justice, but I think if it did one thing, it was to alert the audience to the, you know, the brilliant minds assessing our own case law, which is a huge contribution. I mean, academic musings and thoughtfulness on the development of the case law is part of the development of the law and part of making us bodies of law and making our regions areas where we are respected for as international scholars, you know, on equal footing as any of these other courts that have had you know, a longer vintage. But certainly, I think the excitement, the energy is with these newer courts, and the approach, the Africanization or Caribbeanization, the way we are imbibing the rules and throwing out new case law that these other courts are increasingly taking notice of. So, you know, the CCJ or ECOWAS case law being cited in any of these WTO ECJ case laws is going to be victory, as far as I can see. But we don't need these measurements, right, to be validated. And I think you guys have shown why it's so important for us to have these kinds of fora where we're able to talk to people and our people about the way our courts are reflecting us, reflecting who we are. So these are my closing remarks. I'm sure Kholo will have hers, but let me just take the opportunity in my closing to thank Claude, thank BC for their wonderful remarks in this webinar, and also those who have joined in the 4 previous ones. It's been an excellent, excellent webinar. We're going to try to produce something written from it. And maybe we'll open up another one of these webinars in other regions of the world, because strangely enough, people have been writing me saying, oh, this is such a great initiative. Why not do one with Latin America? Why not do one with Asia? You know, so just really democratizing this trade space so that South-South, South-North, North can kind of speak to each other beyond just the confines of the traditional ways of talking about trade. So thank you all. Thanks to Sam from the University of the West Indies department dealing with IT. Thanks to our co-hosts that I mentioned and co-collaborators, trapca, Afronomics Law, tralac, and thank you to my co-facilitator, who I could not have done this without. We had too much fun on this series, Kholo. So I'm gonna leave it to you to do the closing, and to the audience. I'm seeing Mr. Douglas. Yes, all people who have followed us religiously over the 5 weeks or just came in for one webinar or another, it's been giving us a lot of energy to continue this. So to the audience, thank you so much for your support. That's it from me. Kholo, you can close it out.
Okay, thank you. I will not take much time because I know we've reached the end, but also my greatest of pleasure and thanks to collaborate with you, John, on something that, as you said, started off as a conversation and turned out to be this wonderful 5-part webinar series, talking and sharing about, our own, home jurisdiction, and of course, working internationally when you don't really deal with your own, countries that bring disputes to the WTO court, for example. There's a dearth of that in our day-to-day. And so this has been really enriching for me to learn more about the African system and of course the Caribbean system as well. And thank you to all for your participation. Thank you for your support. This really couldn't have happened without any of you. And I would like to wish you the best rest of the afternoon, morning, and we hope to see you in the future collaborations that we will sure have. So take care and bye-bye.